start. Section 111 within bracket D of the Transfer of Property Act on which the appellant relied does not assist the case stop. That clause provides that a lease of immovable property determines in case the interests of the lessee and the lessor in the whole of the property becomes vested at the same time in one person in the same stop. The clause has no application unless the interest of the lessee and the lessor in the whole of the property is vested in the same person stop. The appellant is the owner of the house. He is also a tenant of a part of the house of which the respondents are tenant from. Mohammed Shafi stop para. When an owner of the property grants a lease to another, he retains with the reversion and transfers the right as a lessee to the transferee stop. When that transferee, the first lessee, leases out the building or a part thereof, further that lessee retains with him the reversion of that sublease and transfers to the sublessee only the rights of a lessee under him stop. Even in spite of the transfer of the reversion of the first lease by the ultimate landlord to the sublessee, the original lessee on the strength of the tenancy created by him is entitled to seek eviction of his tenant, namely the subtenant, on the strength of his letting. The fact that the subtenant had acquired the ultimate reversion might not stand in the way, since so long as the tenancy in favor of the original lessee is not terminated in the mode known to law, that lessee would continue to enjoy the rights of the transfer in his favor by way of lease stop. The merger takes place in terms of section 111 within bracket D of the Transfer of Property Act only in a case where the interests of the lessee and that of the lessor in the whole of the property become vested at the same time in one person in the same right stop. In N versus K within bracket supra such a subtenant had rightly approached the rent control court for eviction of his lessor, the lessee, from the landlord by invoking the relevant provisions of the Rent Controller Act on the strength of the transfer of ownership in his favor by the head lessor stop. The rights under the original lease still continued with the original lessee, and the right in the property to process outstanding with the lessee had not come into the hands of the sublessee merely on the strength of the assignment of the ultimate reversion stop. It could not, therefore, be said that there was a coalescing of the interest of the lessee and the lessor in the assignee landlord in respect of the original lease in the whole of the property as contemplated by section 111 within bracket D of the Transfer of Property Act stop. The decision in N versus K supra is of no